Welcome back to Independent Directors Program by the Boardroom Mentors. This session will be loaded with case studies, so get ready for loads of fun. In the last two sessions we have discussed what is a company, various classifications of companies, what are the various authorities involved in formation of a company, important documentation and steps to form a company. This session we will discuss the rules that govern a company, double-click on Memorandum of Understanding and Articles of Association, and discuss who are promoters.
Let us start today's session with a 1963 Supreme Court case between Lakshmanaswamy and LIC. In 1955, the directors of United Life Insurance Company, including Dr. Lakshmanaswamy, passed a resolution to donate 2 lakh rupees to a trust that promoted technical and business knowledge, something not connected to the company's life insurance business. Later, when LIC took over the business of United Life Insurance, it found that this donation was outside the powers of the company, since it was not related to life insurance. LIC asked for the 2 lakhs donation to be refunded. There were 2 questions in front of the judge: whether the donation of 2 lakh rupees was within the rights of the company, whether the appellant, Dr. Lakshmanaswamy, as a director, is personally liable to refund the donation. What do you think? Since the company was authorized in Memorandum of Association to solely carry on life insurance business, any action outside this scope, for example donation to a memorial trust for promoting business knowledge, would be considered ultra vires, meaning beyond the company's legal powers. The tribunal agreed with LIC and ordered the directors to repay the donation amount with interest.
In summary, doctrine of ultra vires postulates that a company should not perform anything that is not covered by the MOA or the AOA. This protects shareholders by ensuring their investments are used only for the stated purposes of the company and to provide clarity regarding directors' authority. However, the importance of the ultra vires rule has been diminished by changes in company law that allow companies to have broader objects in their memorandums, and, instead of automatically voiding a transaction that was ultra vires, the law now often places the responsibility and liability on the directors who authorized the act.
The importance of MOA and AOA for a company should have been apparent to you in the last 2 sessions. So let us spend a few minutes to double-click on these documents. The key clauses in a MOA are: name clause, which establishes the company's unique, official name, which must include limited or private limited; registered office clause, which identifies the state where the company's legal address is located, determining its jurisdiction; object clause defines the company's purpose and the scope of its business activities; liability clause specifies whether the member's liability is limited by shares, limited by guarantee, or unlimited; capital clause states the maximum amount of share capital the company is authorized to raise and its division into shares; subscription clause is a declaration by the first members, subscribers, to form the company and subscribe to a specific number of shares.
To ensure uniformity and compliance with the legal requirements of incorporation, Companies Act provides model forms for drafting the MOA and AOA. The formats vary based on company category. Table A has the format for company limited by shares, Table B for company limited by guarantee with no share capital, Table C for company limited by guarantee with share capital, Table D and Table E cover unlimited company without or with share capital respectively. AOA also have model templates to be used in Table F to Table J, in a similar sequence as MOA tables. Take a minute to remember the sequence of type of companies and associated tables.
Let's now discuss another interesting case, from 1934 in Madras High Court. This is the case of Kotla Venkataswamy vs. Chinta Ramamurthy. The SIAAI company had mortgaged its property to Kotla. When the SIAAI went into liquidation, the plaintiff, Kotla, tried to enforce the mortgage on Chinta. But the buyer of the property, Chinta, argued that the deed itself was invalid, as the deed was signed only by the secretary and the working director, not by the managing director, as required by the company's Articles of Association. The court agreed. It said the articles clearly required 3 signatures, and without them, the deed was void. The Madras High Court dismissed the plaintiff's appeal, ruling in favor of Chinta. The judgment reinforced that company documents must strictly follow the Articles of Association, and outsiders cannot rely on irregular acts. It applied the doctrine of constructive notice, meaning outsiders are expected to know a company's rules.
The Turquand rule or the doctrine of indoor management is complementary to the doctrine of constructive notice. It reduces the onus that the doctrine of constructive notice places on a third party to the point where a third party cannot be expected to know what happens inside a company, hence the name, indoor management. The due diligence is limited to what is publicly available. The rule is named after the Royal British Bank versus Turquand case of 1856. A company borrowed money from the Royal British Bank. The company's AOA required a shareholders' resolution to authorize borrowing. This resolution was not obtained, so the borrowing was not properly authorized. The court held in favor of Royal British Bank and against Turquand, the company's liquidator, establishing the indoor management rule. The bank was entitled to assume that the company's internal management had properly authorized the loan, even though it hadn't been done. The bank was not expected to know about the company's internal compliance with its own rules. Turquand rule protects outsiders only when they could not reasonably know about the irregularity.
We will now discuss an important and crucial person for a company formation. This person is the promoter. Who is a promoter? Section 269 of Companies Act 2013 defines promoter as a person who has been named as such in a prospectus or is identified by the company in the annual return in Section 92. The promoter control over the affairs of the company, directly or indirectly, whether as a shareholder, director, or otherwise. This person is in agreement with whose advice, directions, or instructions the board of directors of the company is accustomed to act.
The following legal points should be kept in mind when advising clients who may be corporations or their promoters. The promoter's position is fiduciary in nature. There are duties and liabilities associated with this fiduciary position, as well as all disclosure and accounting duties. Anytime the promoter acts on behalf of the company, it must be disclosed. The promoter must keep a book of accounts in order to be held accountable and the transactions to be transparent. Promoters need to disclose conflicting interests and is liable if she breaches any duty owed to the company.
Congrats! You have completed Module 1. I am sure learning was fun and not tedious. See you in the next module, as you step closer to the boardroom.